Sure. Let's throw our first poll up and start our introductions if that's convenient. And we'll just get everybody's feedback right off the bat.
Sure.
And thank you so much, Carrie and Jonathan, for joining us this afternoon. I'm really, really looking forward to your presentations and participating in this one.
Yeah, what a
Oh.
treat. 2 hours of Carrie and Jonathan.
I don't know if everybody would agree with
A
it.
treat or
Being a treat.
torture? We haven't decided yet.
A treat and an
Well,
honor.
we know we're going to learn a lot and we know we're going to have fun. It's always guaranteed with your presentations.
Well, I
So
always want
first,
to have fun.
first poll question right out of the gate, even before we get to intros. Have you ever experienced impasse? So we'll give everybody a minute and let's find out who we're presenting with today, Shannon.
Sure. So if you haven't seen our programs with Carrie and Jonathan before, I'm just going to take a moment to introduce them. So Carrie Heinzel is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for seasoned practitioners. She sits on the board of directors for York, and Durham Collaborative Practice and is the president of the OACP. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition to that, Carrie has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution, Institute Ontario Annual Conference, and the International Academy of Collaborative Professionals. Thanks so much for being here, Carrie.
My pleasure.
Next, we have Jonathan Painter. Welcome back, Jonathan. Jonathan is
Thank
a
you.
registered social worker and psychotherapist who works in the family law system, completing parenting plan assessments, voice of the child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, and couples counseling for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of the Collaborative Practice Durham region. So today we have Carrie and Jonathan presenting alongside Russ with a presentation on impasse. And I'm just going to go back here and nope, I'm just going forward. Just having some technical difficulties here, everyone. But before I get started, I just wanted to do a quick summary of what they'll be going over for all of you. So they will be discussing, oh my goodness, you think I know this by now. How to control the PowerPoint.
I think we're going to be discussing impasse.
Impasse,
Yeah.
yes. What it is, what it's not, conflict styles, preparing for impasse, distorting the separation, effective communication strategies, bring in the neutrals, bring in the lawyers, boomerang cases, and they'll also be sharing some case studies, and we'll do our best to save some time for Q&A throughout. So as I mentioned, you can send in your questions through the Q&A, and we'll be answering those. I imagine we'll have some time while we do polls, but also towards the end of the presentation as well.
All right. Thank you so much for those kind of introductions, Shannon. Maybe we could see the results of our first poll.
Absolutely.
So have you ever experienced impasse? Yes, 77%. Wow, that's pretty common. 4% said no. What is impasse? 17%. Well, must be a really effective lawyer, a really reasonable client if you haven't had that. And 2% other. You can just put that in the chat box or the Q&A box, and we'll find out what that is. So thank you so much. Big theme of what we're going to talk about today is normalizing impasse. We're going to talk about it, give you some strategies. In my view, the biggest takeaway is you want to normalize this right from day one. So when I meet with my new clients or am I doing a consultation, I explain this is a normal part of the process. There'll be impasse regardless of what process you're in, if it's negotiation or court action or a separation agreement or collaborative practice, is commonplace. But who wants to start us off with the definition of what impasse is? Carrie, you want to take a swing at this?
Well, impasse, quite frankly, is the easiest definition is you just don't agree with what's being presented in front of you. You have two differing opinions, two differing thoughts of what's really going on in front of you. And an impasse can be all different sizes. It doesn't necessarily mean it's something big. It can be all the way down to you guys having a disagreement about how somebody likes to take their cup of coffee. That can be an impasse. It can
Who
also
takes the
be as
last
big as
donut?
Yeah.
exactly. Well, in that case, Jonathan, I'm going to tackle you if you take the last donut, but that's beside the point.
Jonathan, your thoughts on what impasse is?
Yeah, I mean, it's just whenever there are competing interests, and in negotiations, there's always competing interests. It could be, something minor, like I want a 4:30 p.m. pickup for the kids instead of a 4 p.m. Or it could be something major, like I'm not giving you any of my pension no matter what. So usually there are emotional issues that underpin the impasse. And that's kind of what today's presentation is about. It's about kind of understanding some of those emotional, psychological underpinning issues that can cause impasse.
And it can come
But
at any time. It can come at
what's
any
that?
time, right? And it can
Yeah.
derail an entire agreement. Let's go into story time for a moment. I had a client, no kidding. The whole case was settled. We were down to one Kirby vacuum cleaner. Now I'm dating myself. 30 years ago, people used to go door to door and sell vacuum cleaners that would cost like $3,000 or $4,000, right? You'd put it on a payment plan. And long story short, this professional couple, they're both college professors, had a disagreement over the vacuum cleaner. My client, the husband said, I want the vacuum cleaner. Wife says he's never vacuumed a house in 20 years. The case was done. And so we're going back and forth. I said to the landlord, what's going on? Why can't we get through this? My guy really wants the vacuum cleaner. And he goes back to his client. The wife says, he doesn't even own any carpets. Right? So it wasn't about the vacuum cleaner, is my point. There was an unresolved underlying issue, which is what you're talking about, right, Jonathan?
That's a great example, Russ. Yeah, the vacuum cleaner isn't really the issue. It's the emotional issues that underpin it. And in that case, the husband sounds like he found a really great way of just jabbing in a little shank into the side of his ex, figuratively, by trying to get the vacuum cleaner off her. So, Carrie, what would you say is not impasse? Russ, too. What do you think
Oh, what is not
impasse is not?
impasse?
Yeah.
Oh, that's actually a great question. So impasse is not a sign that someone's failing or that they're doing a bad job. So often we take impasse as this, oh, well, I'll throw this entire process up in the air and throw it away because it's not working. It's not that. Impasse is normal. It's going to happen in everything that you do. So to say that you're failing, that's not impasse. Doing a bad job, that's not impasse. That's just a feeling that you may have as a result of it.
And it's not a sign that your clients are a problem, right? Oftentimes, I hear many lawyers say, "Oh, I've got this nightmare client," or the client's a problem. They're legitimately allowed to have their views and opinions, and if they're hitting an impasse, it's up to the professionals, especially if you have a full team, to drill down and find out what the underlying issue is. It's usually not the issue that they're deciding that they want to die on this particular hill. There's usually something else going on.
Absolutely. And you know what? It's also not a sign that you have to go to court. If you're in collaborative process or if you're in mediation or any other types of alternative dispute resolution, it's not the sign that you need to go and run into court and have a judge decide the issue. It's usually meaning that you just have to dig deeper into something. And sometimes it's not even that. I've found so many times when we just sit and you listen to what the beef is or what the total problem is, that person just being heard is sometimes all it takes to get past to the next level. So you don't take it as, oh, this everything's failing, we must run to court.
Yeah, and probably
Or sometimes I find like a break can help too. I often in my negotiations come up against the impasse about Christmas, and people can go away feeling very upset and not agree about how they're going to share time with the kids on Christmas. And then often what I'll do is suggest, well, why don't you just take a break? We'll come back to it next week and talk about it again then. And that is often enough to just give them time to, emotionally decompress and turn their minds back to it. And they realize, oh yeah, I was kind of being unrealistic and maybe a bit of a jerk by saying that the other parent can't have the kids on Christmas ever. So I find sometimes just people need to calm down and think things through a bit, and that can get you through.
Have that soak time with the idea.
What I hear you saying is that separation agreement that says Christmas time is to be shared equally is not detailed enough for some people.
Great active listening there, Russ. Yes.
I want to do I didn't want to do the loop. Did I get that right?
Yeah. I mean, it depends on the level of conflict in your clients. If your clients are people that get along and they can sit down and have a coffee and talk about the kids and agree to things, you may not need to specify a time. But if you're involved in a high conflict case, which we often are, better to specify, get as much detail in that agreement as possible to prevent future impasses about, interpreting the agreement. So I think your point's very well made.
It's not a sign that the collaborative process or mediation is not going to work for this family or these clients. One of the biggest objections I used to get, not anymore, is, well, what if we can't agree when I'm introducing clients to the collaborative process? And part of that process is the lawyers agree not to go to court. So if they don't get an agreement, we're not going to take your case to court. You need to go find new lawyers. This is one of the fundamental underpinnings of the collaborative process because we want everybody to buy into it. And the objections I always used to get were, well, I want you to be my lawyer if I go to court. And what if we don't agree on something? And I don't want to use collaborative practice because so-and-so will never agree to X, Y, or Z. And that's a pretty big objection to get over and sort of explain to the client there will be impasse, but that's normal. That doesn't mean court is going to be a more effective process to deal with that. You may get a judge to make an order to break the impasse, but it might take you 2 years to get a trial date before a judge is prepared to make that order, especially if there's conflicting evidence. So I find that clients who are genuine about the collaborative process help find a way to work through the impasse. But let's
Russ, sometimes I find just asking clients why they think court would be more effective to be a great question to ask. What's their expectation by doing that? It's a great way to get over some of the impasse with those objections, because sometimes they're dealing with a movie or a TV version of what reality is and not what's really going to happen.
And I get a lot of clients after they've been in court for 2 years and they come see me and, there's a heated court case, high conflict, runaway train. We've talked about this extensively. And when I explain the collaborative process to them, they'll say, well, why didn't somebody tell me about this 18 months ago? I didn't realize there was an option where I didn't have to go to court to resolve issues. So really important aspect of collaborative process, which we're talking about today, is how to get work through impasse. But the lessons you'll learn today will work in litigation files and mediation and arbitration. So the next poll question for our audience is, what issues most often lead to impasse? You've got a series of choices. You can choose more than one. And while we're doing that, let's go to an audience question that came in advance. Maybe I'll throw this one to you, Jonathan. How does power imbalance between the parties likely affect the reaching of impasse?
Good question.
It definitely can significantly influence the development of impasse, right? Because usually if there is a power imbalance, that could mean that the person who's kind of in a position of power has what we call kind of a rigid way of thinking. So they tend to be more positional, like I want this in the negotiation and I'm not going to accept anything else. They tend to be less mentally flexible. They're not really good at of taking in new information and using that new information to change their belief systems. Their belief systems are very, very solid and hard to deal with. And then you're also dealing with the person who's has less power in that dynamic, feeling like, oh, I just want this to be over, and I'll let them have whatever they want, or maybe the request that they're making, maybe the demands that they're making are really unreasonable, and the person with less power, is reluctant to agree to them. So yeah, that can have a major impact on impasse, and that's why it's really, really important for us as a team to set ourselves up for success by picking kind of the best team possible, and B, by preparing our clients as much as possible to address the impasse before it arises. So Carrie and Russ, you guys talked about clients' expectations, and when clients hear collaborative, they think, well, collaborative means we're never ever going to disagree, and the second they find a disagreement, they're like, oh my God, the whole process is a waste of time and useless. So explaining to them ahead of time that collaborative doesn't mean that there aren't any disagreements. It just means when there are disagreements, we work together as a team to overcome them and find a way around them. See them as a barrier, not as an impassable wall.
Great questions coming in. Please keep them coming in. We love the questions. Monica just sent this in. I know you answered it, Carrie, but I think the audience would benefit from this. Sometimes impasse happens when one party does not want the process to end. In other words, they're not ready for the relationship or interaction to be over. That's actually quite more common than you would expect. So Jonathan, we've got the agreement, we're all signed up, and then, somebody finds something to drag it on. Or, we'll talk a little bit about boomerang cases. What do you do with these clients who don't want the relationship to end? Or maybe they feel special, right? They have all these professionals giving them this attention and spending these days with them in these meetings. And once that ends, they go back to the regular life. They're not going to have that spotlight on them anymore. So how do you get over that aspect of impasse?
Yeah, that's a good question, Russ. And I kind of experienced that a little bit when our firstborn was born. We had our oldest child at home, and with midwives. And when the midwives were preparing to leave, we were like, no, you can't go. You can't leave us alone with this child. It's not going to survive the night. So I kind of get that feeling when people are reluctant to end the process, because they're going to lose all these supports. They'll lose, Carrie giving them financial advice, me giving them, emotional support, Russ giving them legal advice. But a lot of the times it's more about the relationship and what the relationship meant to the clients. And if someone really doesn't want the relationship to end, they're going to lose more by the relationship ending than the other person. That's when you kind of tend to see that reluctance, and you might see them missing meetings or being really distracted during meetings, or not getting their homework with Carrie done, or not responding to your messages, Russ. That kind of avoidance behaviors that might signal that there's some kind of underlying emotional issue, that the client is really having a hard time getting through the separation and just getting their mind around it. And it can be a really hard psychological healing process to recover from separation, even if it's the right decision. And so that's where a family professional can really help by meeting with a client and getting to the bottom of a lot of those emotional issues, and just helping them accept that the relationship is ending. In psychology, we use the term radical acceptance to help clients deal with very tough situations that they don't have control over. So that might be, getting disabled, having an injury or an illness that makes you disabled. It could be losing your job. It could be one of your kids has some kind of really serious long-term illness, or it could be the end of a relationship. And if you're having a really tough time dealing with the end of the relationship, accepting it, it might be a good opportunity to reach out for therapy.
Okay, let's go to our poll results. They just ended actually. Oh, here we go. So issues that most often lead to impasse: property division, 43%, sale of home, 29%. Parenting time, that's always a big one, 64%.
Mhm.
I think that sometimes leads into support issues too, right? Some parents think, okay, my support obligation is going to be determined by my parenting time. Holiday schedule is always a big one, 32%. It's amazing that we still don't have that worked out. Reluctance to settle, we kind of just talked about that, 30%. Support issues, 46%. And who gets the Kirby vacuum cleaner? Yes, we've got 7% agreeing with that story about the Kirby vacuum cleaner. I want to go to one more question, and then we're going to go to conflict style. So how often do family law cases reach an impasse, and are there common triggers? So maybe we'll get to the triggers in a moment, but let's just do a quick rapid fire roundtable. Jonathan, how often you say your cases hit an impasse?
Almost every time. There's always some issue that's tough to get through. It doesn't mean that that impasse is permanent and that you won't get through it, but I see, for me, the most common issues I would say were parenting time and spousal support. Those are the two issues that come up. I'm curious about your survey results, Russ. It seems like a lot of people have had issues with Kirby vacuums.
The
There were
vacuums are
7
great.
people that said that they'd experienced that. So
I should have
that's not an impasse I've ever experienced.
I should have put on Who Gets the Family Bible. That's another one that we didn't. Carrie,
Yeah.
how often you see impasse?
I'm going to say 100% of the time, beware of the file that comes to you either by the clients or somebody else saying, this is an easy file. That is the
That's a
kiss
red flag
death.
right there,
That
right?
is a massive red flag. For me, I just go, oh, this one's going to be a mess. It just doesn't feel good. I know it's supposed to be a happy thing to hear. It's the worst thing for all of us to hear because that's the one that all of a sudden gets really, really messy. So you know what, impasse is going to happen all the time. I don't think I've ever had a file where there wasn't some level of impasse. I think that's the difference is when we don't normalize impasse, I think it becomes harder to resolve. I think when we're aware and willing to be actively working with it, then I think it becomes a much more manageable thing to go through.
Yeah, you need to talk about the elephant in the room. It's like you're on the highway and you see the construction warning signs, and you see that in family litigation and collaborative practice, right? You see warning signs of impasse
Yeah.
all the time. They take it all different shapes and sizes. Something that seems relatively minor can blow the whole case up.
Yeah.
So the answer is it's frequent, maybe if not always, and maybe not always because the professionals pick up the road sign saying we've got an impasse approaching, how are we going to do it, and work through it before it becomes impassable, right? So
Absolutely.
conflict styles. Jonathan, what does our audience need to know?
Yeah, so a bunch of people far more intelligent than me came up with this kind of model of conflict, which a lot of collaborative courses have in, and I find really helpful to help understand how people tend to behave in a conflict. So we are all born with a personality. That personality gets added to throughout our life based on our life experiences, and that personality tends to engage in certain patterns of interaction with other people. And so the conflict style model has 2 dimensions. One is how goal driven you are. So you either really, really want to reach your goal, or your position, I guess, or the goal may not be the important part. It might be the relationship that's the important part, or other factors that might be important to them. The other dimension is the relationship, how important the relationship is. So if your relationship is really, really important with your ex because you're co-parents, then you're going to behave very differently than if you don't care, or even worse, if you actively hate the other person. So understanding that both your clients' conflict styles and your coworkers, your team's conflict styles can be really helpful, because certain combinations can be really problematic. So for example, if you have a competitors are very goal driven, and they don't value the relationship. So they want to win in the negotiation, and they don't care whose, emotions they step on to get their goals met. Some people call those the sharks, right? Because they're going around eating everything and trying to consume it. And then if you have the opposite end of the spectrum, an accommodator, that's someone who's always, giving and always giving in to the other person and saying, oh, what, if they're in a dating relationship, what movie do you want? Which restaurant do you want to go to? What kind of food do you like? All those kinds of things. You're going to have a bad combination because the shark is going to get everything they want. The accommodator is going to get nothing they want, and they're going to feel really, really unsatisfied with the process, and that might influence the success of your negotiation. So understand that ahead of time, and working with your clients to move them kind of into the middle. So the shark you would move to be more amicable, more compromising, more, a little bit more accommodating, whereas the accommodator you would work to be, more firm in their positions and more, setting boundaries and standing up for themselves. So that kind of information can be really, really helpful to know ahead of time. And the other styles of conflict are the collaborators, and they just want, they're very goal oriented, and they value very highly the relationship. So they want to work together to create an agreement that works for everybody. They're the best kinds of clients to have. And if you got two of them, count your lucky stars, get a lottery ticket because you just won the lottery. And then there's the avoiders. Those are really difficult to deal with. Some people call them the turtlers because they kind of withdraw into their shell, and they're the ones that, we've already talked about. They don't get their financial disclosure to carry. They're not returning emails. They're missing appointments, that kind of thing. And then the middle ground people are the compromisers. And they like to find a common, they want to find a middle ground between them and the other party, and they're pretty good to work with as well.
What about the one where there's infidelity and one client just wants to give up, right? Or another client wants a premium, right? I should get more.
Yeah.
That's what part of your conflict models or styles would that fit into, or would it be a combination?
Yeah. So, if someone's angry about an affair and wants to punish them for that affair by, getting way more out of the financial agreement than maybe they're entitled to, that would probably be a competitor, a shark. They're trying to win by defeating the other person and damaging them in the similar way. It's kind of an eye for an eye kind of philosophy to conflict. Like if you did something horrible to me, I'm going to do something worse to you. And often you will find the person who had the affair feels very guilty about it, and they might be more willing to accommodate the other person. So that's where the team can step in. Carrie and you, Russ, can step in and talk to the client and say, hey, you know what? I understand you're feeling guilty about all this, but think of the consequences if you agree to give everything you own to the other party. How is that going to affect you and the kids in 10 years and in 20 years? So getting them to see the long-term picture can be a helpful way of getting accommodators out of that guilty mindset. I'm just going to give the other party what they want because I feel guilty.
Or they may take the opposite mindset and say there was no affair, and the first spouse has to get this admission that there was, right? Needs that validation, which leaves impasse, right?
I sometimes find with accommodators, they do it also because they think that, well, I'm going to give you this, you'll be nicer to me, or, you'll stop doing certain behaviors. And it never happens. I've yet to see where somebody giving more has allowed the other person to go, oh, you know what, you're being really reasonable and generous, so I'm going to do the same. I find that for the most part, the other person goes, great, thanks.
Yeah. Next poll, what are common barriers to resolving impasse? So multiple choice again. Let's find out what our audience thinks. And more audience questions coming in fast and furious. Thank you so much. We're going to get to as many as we can. Oh my God, look at the quick result with those poll results. Didn't even get a chance to ask my question. I can ask the question anyway, and then we're going to get to the result. Has there been an increase in impasses, repets, as more and more couples are refusing to have kids, instead own pets, cats, dogs? Has there been an increase in trend? If so, is it different? Is there, do they differentiate parenting time? What about the best interest of the pet? I don't know. You guys seeing impasse over pets?
Yes. Did you know that there was actually an article that came out about BC, and they've actually changed how they're dealing with pets. They're not seeing them anymore as being property. They're now seeing them as being part of the family.
Change the
And
legislation out there.
there are times I know where I would have, when my kids were little, I would have replaced them with my animals, happily given them to somebody else. I think that was around when they were 15 and learned how to be
You can't,
mouthy. I think that was
you
around
can't
that
take your
time.
kid, can't take your kids back to Costco when they turn 15 and
No, you can't do that. And I didn't have enough money for boarding school. So,
I know. We had a case pre-pandemic. It's funny how things are measured in pandemic times.
yeah.
And husband insisted he wanted access to the dog, which was clearly the wife's dog. And so we set up a parenting schedule. You know, he had Wednesdays and alternate weekends for him to have access to the dog. That happened for about 2 weeks. He just wanted to have access to her. And she would have a friend or family member do the drop off, and then it faded. So some of these pet concerns are valid, and sometimes the claims are being made for nefarious reasons.
Yeah.
Or in that case,
Especially now with
maybe he was having a hard time getting over the separation, and that was kind of a link to his old life that he wanted to hold on to for as long as possible.
All right, let's hear what our audience is thinking. Common barriers to resolving impasse: misunderstanding, 42%. Poor communication, 51%. I certainly agree with that. Trust issues, always up there, 63%. Emotional factors, well, that's why we bring Jonathan into the room, 60%. Power and control, 57%. Vindictiveness and retribution. Yes, there's no place for that in the family court, but it keeps showing up. 55%. Psychological health, mental health issues, 31%. Not wanting, ready to settle. Yes, we've seen that this afternoon. Fear, uncertainty in around the 20s, and other, you put that in the chat box. Thank you. So really, it could be anything is what our audience is telling us that we can hit impasse on. And in my view, this is why it's important to bring a team in, but we're going to talk about that more in a moment. But let's talk about preparing for impasse. Jonathan, you want to take the lead on this?
Sure, yeah. So one of the things that we thought would be helpful to talk about is pairing your team, like getting the right team together to address the impasse. So pick your favorites, pick people that you trust, that you've worked with before. If you haven't worked with people before, get to know people, attend collaborative meetings, go to collaborative conferences, go to events where you can network with them and get to know them on a more personal basis, and that will develop those important relationships and trust. And generally, when you're picking your team, you want people that are high on. So I'm going to talk about what's called the Big Five personality model. And the acronym is OCEAN. It stands for openness to new experiences, conscientiousness, introversion, extroversion, agreeableness, and neuroticism. And those are all things that are part of our personality that are pretty stable over time and can kind of help you understand who you are and who your team members are. So agreeableness is a measure of how empathetic you are. And when you're doing family law work, you have to have a lot of empathy because you're working with people who are going through their worst period, potentially of their entire lives. And they need a lot of help and support, both, practical support, like crunching numbers and understanding laws and blah, 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 but also emotional support, active listening and validating and, all the other kind of supportive things that the team can provide for them. So getting team members that are high in agreeableness who have a lot of empathy is really important because they're going to work better with clients who are going through difficult times. You want generally to have team members that are low on the neuroticism end of the spectrum. Neuroticism is a measure of how anxious you are, and anxiety is an emotion that's very infectious. So if you have one person who's anxious in a room, it's going to spread to the other people in the room. So if you have someone who's really high energy and they're talking like this all the time and they're, oh my God, I don't know how to deal with this. They're going to ramp up the clients and make them feel more anxious about the process as well. So you want someone who's calm in a storm, who's not going to freak out themselves or freak out clients by getting upset. And then lastly, I would suggest people high in the conscientiousness scale. The conscientiousness is a very difficult word to say, and B, it kind of means how organized you are. And so you want someone on the team to be high on that scale because they're going to be the ones who are driving the process, making sure we make appointments, meet deadlines, and those kinds of things. So before you meet with the clients, it might be helpful for you guys to meet as a team and talk about process, get to know each other a little bit more, and talk about what are the likely impasses based on the information we know so far. What are the topics that we're going to have the most difficulty handling, and what are the topics that are going to be much more easy to resolve? So that's kind of my thoughts on preparing your team. What are your thoughts, Carrie and Russ?
The thing that I like about the team approach is clients are different with different members of the team. So what they tell their lawyer is going to be this much. Then what they tell the family professional might be a little bit like this. And then that's the same for the financial professional. We're getting bigger snippets, and the benefits of having a neutral financial and family is we're hearing both sides of the story. So we're hearing where they're aligned, and we are hearing where they're not aligned. We are your first defense on impasse of the file because we're getting it firsthand and we're getting it early. So we can have really great communications so that we can say, hey, entire team, here's where we may have some issues. For me as a financial, it may be saying to the team, we're going to have issues with the house. They both want it and they're not willing to budge. Or one person wants it, the other person is insisting on sale. It's allowing us to give those red flags super early. And then sometimes there are points where I'm hearing somebody say, they controlled the money. They controlled the money. I don't know anything. They controlled the money. That becomes a really great cue for me to talk to my family professional and say, hey, Jonathan, is this a matter of a power and control issue we're going to have? Or is this simply the rules that were conducted throughout the relationship? So we're giving those early warning signs right up front, which means we can start dealing with impasse before it happens.
Yeah, I agree. What about distorting the separation? Well, let's go to an audience question because I think this kind of ties in nicely to where we're at. And I appreciate all the questions coming in. They've been fantastic. Just on this concept of impasse, a questioner asks, can it be temporary or how long does it usually last? I think if you don't deal with it, it could derail the entire case. But what's your experience, Carrie?
It's really funny because I have seen things where people have thought that the impasse was going to be massive and it was going to be a really big deal, and we resolve it very, very quickly. And the reasonableness comes out and everybody goes in. There are other times where I've seen where I've had to do things where I like to say throwing in the holy hand grenade, where I'm pulling the pin and having to tell the team some really, really bad news. That's always a good time for me. And those can take a little bit more time to get through. It depends like how the issue is and how readiness the clients are ready to hear things, or even how ready some people on your team are ready to deal with the matters. I know I have an issue where, we have parenting concerns and it's a big piece of impasse, and there's a big financial part that goes with that. And so it's now, let's pull it back, and we're going to have to pull things apart a little bit more before we can move forward. That's going to take way more time than just some of the other issues that we may have. Maybe, who gets the family Bible? It might be a smaller issue.
Who gets the family? But what that timing where that song? I can't remember. Okay, let's talk about distorting the separation, Jonathan. What do we need to be mindful of in terms of the client's view of the separation and how it can inform or create impasse?
Yeah, this is where kind of the fields of family law and psychology kind of overlap nicely. One thing that you'll find a lot in impasse situations is what are called cognitive distortions. Cognitive distortions are patterns of thinking that are normal in people, but they're inherently irrational, illogical, and they can cause major problems. So examples of this might be something like all or nothing thinking, where if people are either good or evil. There's no kind of in between. Good people don't do bad things, and bad people don't do good things. We know that there's lots of shades of gray in between those two extremes. But if you're engaging in all or nothing thinking, you might think, for example, that the marriage breakdown was 100% the other person's fault. I have no responsibility for the breakdown. It was all their fault. So that would be an example of all or nothing thinking.
I know
Catastrophizing.
I know lawyers who approach cases that way, right? They start emoting their client's behavior. And they take on the fight, say, "Oh yeah, your client cheated on my client," and it's all or nothing. They think the client cannot tell them no wrong, and they don't think outside the box. And
and we know, like from a psychological point of view, affairs are a very complex situation, and there's a lot of complex reasons why they happen, and having a really simplistic explanation for this kind of complex behavior is never really that helpful. It can really drive, like, if you think the other person's 100% at fault for the marriage ending, then your negotiation stance is going to be very different than you think, well, we both screwed up, we both made mistakes, we're both partially responsible for the end of the marriage, and let's find a way to amicably separate and get along. So there are lots of different cognitive distortions that can cause problems. All or nothing thinking is just one of them. Another good one is catastrophizing. So, for example, I had a case recently where the husband was saying, she wants to bankrupt me. Saying that about his ex. So I asked him, well, what do you mean by that? Well, she wants me to buy her out of the matrimonial home. Well, she's not trying to bankrupt you. She's just trying to get her portion of the value of the house, which she's 100% entitled to. So helping clients address those thinking errors with, things like logic and reframing. Reflective questions are really important. Like, do you really think that that's why? Are there any other reasons why she might want the house, for example? Or another good example is
I'll be a bag lady.
Reason. Yeah. Emotional reasoning is another good example of where it's a cognitive distortion where someone feels a certain way and therefore believes the feeling's true. So they feel angry at their ex-spouse. That means that they're an evil person and they deserve their hatred and disrespect. So so the team member's job is to identify these cognitive distortions, B, trying to get ahead of them by, doing things like reframing and asking reflective questions to get people to engage in what's called flexible thinking, to change the way they believe based on new information. So yeah, lots of different options for addressing those cognitive distortions. And that's why having a family professional can be really helpful, because they'll have, a lot of training experience on those cognitive distortions.
We'll get to this in a moment, but I think it's essential to start with the full team. And it's cost effective. I'll explain why in a moment. Impasse, what strategies do you use to overcome impasse? So we've got a number of options here. Let's go to another audience question because they're simply fantastic. And thank you so much for participating. Jonathan and Carrie, what are the warning signs that impasse may be approaching in negotiations? So we talk about the highway construction signs. So what are some of the signs you want to look for? What do you see?
Well, I think Jonathan's
feeling in your stomach.
Yeah.
You see clients having emotional reactions in meetings, crying, shutting down,
Yeah.
not participating, um, just disengaging are a number of
Being
things.
very positional right from the beginning,
Right.
positional attitudes towards, things that, maybe should be more flexible, like saying that the other parent should never have the kids on Christmas Eve and Christmas morning might be an example. Yeah.
Yeah.
Very, very nuanced things like canceling meetings last minute,
Yeah.
rescheduling, not providing the professionals with the information that they need, maybe over focusing on one specific issue or one specific event during the course of the marriage or the breakdown. There's a number of triggers that you see. What about you, Carrie?
It can come down to the simplest of things. It can be coming down to just fear-based, that even they are really rational when you're talking about each of these things on an individual basis, but it's the whole fear of the unknown can cause an impasse all on its own. People want some degrees of certainty. They want some degrees of, I'm going to be okay. And that paralyzation of fear alone can cause an impasse. And it's a little bit more difficult to get past. We don't have crystal balls. We can't predict people's future. What we can do is just simply set them up for the best possible way forward, and then it's up to them. And just because you're at one point at the date of your separation and going through the process doesn't mean that you're going to be in that same point 10 years from now.
And I
So
find
it's
the
helping them realize.
professional team as a lawyer are really can be my eyes and ears because a client may share with Jonathan or with you, Carrie, something they didn't share with me during the consultation. Or maybe they shared it and I didn't think it was overly significant. It could be the issue of a family cottage that has to be divided, or it could be an emotional issue that they didn't want to talk to their lawyer about, but they talked to Jonathan about it. So we have these professional calls before we have team meetings, and these issues get discussed where otherwise they might have just got buried and the client would feel their voice isn't being heard and the process is just not working for him or her.
One thing that I find is a really big piece of impasse is people not understanding the differences between some things. So an example of that is a gift versus an inheritance. So I find that sometimes language gets lost, or the expectations around an inheritance where one person has received a lot of money and the other person has an expectation that they should be entitled because they cared for that person before they passed away, or they had a really good relationship, and how dare they not put me in the will now? And why does this happen? Or you hear the opposite. Well, their parents are going to die in 5, 10 years from now. They're going to get a lot of money then. Why do I have to give them any of my money now?
Or
So,
my former spouse is going to die, so why do I need to settle with him or her?
oh yeah.
That's a real case example. It's incredible what can create an impact.
That still gives me post-traumatic stress disorder, that matter. I'm not gonna lie. It still gives me heart
We're not
palpitations.
supposed to talk about it anymore. It doesn't help the recovery process. So let's see what our audience thinks. Strategies to use to overcome impasse. And the results are, oh my God, Shannon's just so fantastic.
She
Uh,
really is.
Reframing, 49%. Examine the evidence, 37%. Reflective questions, 38%. Educating clients, yes, very big. Top results, 64%. Encourage flexible thinking. There's a lot of lawyers who are not, who are, firefighters and, they're warriors and they think they just need to burn everything to the ground. And some of them are more peacemakers. So I think some of the lawyers could encourage more flexible thinking than they do sometimes, at least in my experience. Okay, so that leads us to our next topic, effective communication strategies. Jonathan, what do we need to know here?
Yeah, so one thing that we can do with clients is to help model good communication strategies with them. So teaching them about active listening can be really important during meetings. And so often you'll see either during my intake process and or during the first team meeting, before we even talk about goals and interests in a collaborative setting, for example, or in a mediation session. I'll talk about why active listening is important and how to do it. So that means you're really listening to the other person. You're not preparing an answer without hearing what the other person's saying. I call it loading your gun. So sometimes when the other person's talking, the person's kind of loading their gun and they're not really listening. And they're ready to blast them the second that they stop talking, instead of like taking a step back and really trying to hear what the other person's trying to say. So active listening can be really important. I teach clients that there are some rules of communication, right? If you say something positive, you're twice as likely to get a positive response compared to a neutral comment. But if you say something negative, you're 5 times as likely to get a negative response. So negative comments downward spiral really quickly. It takes a lot of positive communication to build it back up. So teaching clients to do something called make requests instead of demands. Demands would be things like, you have to, you must, you're gonna, I need you to. Those are the kinds of things your boss or your superior officer is going to say to you, and you have to jump. But you don't want to hear those kinds of comments from your ex, because if they're telling you what to do, you're going to get angry with them. So changing those into requests can soften it and turn it into positive language. So things like, would it be okay if, would you consider, could we do this? Could we try that? Those can automatically make the other person more open to hearing a proposal that you're making, while you're engaged in that option generation phase of collaborative that Carrie and I are going to talk about next. So just teaching clients how to use basic communication skills and modeling them yourselves, making sure your comments with the team are very respectful and that the professionals aren't, contributing to the impasse themselves. Harry, what are your thoughts?
Oh, my thoughts on that is the moment I hear somebody say I should do something or I have to do something, I don't know about you guys, but I put on my stubborn boots. Um, that's my immediate go-to. So I completely relate to the idea, don't tell people what to do. But for effective communication strategies, quite frankly, you know, giving clients information, explaining things, opening up that communication with them and really having them understand things. And by the way, it doesn't mean just telling them the good stuff. We've got to be telling them, here are the bad things that go with this. Like, this is the good part for you, this is the bad part for you, and vice versa. It's really about giving them the full information. They need to be free to make those decisions on their own. It's a really big deal. And then in that, it's easier to encourage the flexible thinking that we've been talking about so much today. It really is a big deal that people kind of are able to see something outside of their mindset. And I find sometimes when we do that, or a way that I've gotten people to kind of look at things maybe a little bit differently, I ask them to see something from their spouse's point of view, from the other if this was your spouse, if you were your spouse and this is what was coming at you, what would be your reaction? And the odd time I get a real smart ass answer back, which I know to be not true, and that happens. But for the most part, I get a lot of people that are going, I didn't think of it that way. And it really does start opening up that thinking a lot better. It gets people to be more resolution oriented rather than impasse oriented.
Yeah, and the collaborative practice agreements have communication guidelines attached to them as a schedule. I like the approach of having, if we're dealing with a support issue and my client has to pay support, I'll raise that issue and talk about the law on that issue. It's just less adversarial, it's more flexible. My client's not going to feel like they're being confronted by the other spouse's lawyer. So there's lots of little nuances. But sorry.
Sorry, Russ, I was just going to say, all of this isn't just for collaborative practice.
Right.
I know so many lawyers that do so much better in their litigation practices because they know and understand collaborative principles. They may not practice collaborative, but they've done the training, they understand the principles, and they apply it to their litigation. And they're having great results because of it. Because most of our judges, they're now collaboratively trained.
Use this in mediation and arbitration outside the collaborative setting as well. So
Absolutely.
I may have spent a little bit too much time on audience questions. So I'm just going to speed up the train a little bit here and talk about neutrals. And then we're going to talk about lawyers and finish off with boomerang cases. So thank you, everybody, for submitting your questions. They've been simply fantastic this afternoon. So for neutrals, I like to bring in the full team. What that means to me is I'll bring in a financial professional, usually agree with the opposing counsel or the collaborative lawyer, which one person we're going to use. That adds credibility to the disclosure. It adds efficiency. We don't have two lawyers preparing two sets of briefs. It avoids the merry-go-round of disclosure requests and motions, and it's a much more efficient way to proceed. I'll bring in family professionals similar to Jonathan. That's going to assist in flagging all these issues that could potentially lead to impasse. The emotional, the communication issues, the issues clients are not sharing with their lawyers. Oftentimes we have a draft parenting plan ready even before we meet for the first meeting. So those several hours of traditional lawyer negotiation has been saved by bringing in a family professional. You can get parenting plan assessors involved, business evaluators. Voice of the child reports is also a very effective tool, especially if you have older children, 14, 15, 16. Get their views. It's certainly the flavor of the day if you're going to court. Judges will often want to hear a voice of the child report, either formally through the OCL or done privately by the clients. Litigators are somebody you can bring in to give the clients a second opinion. And this team can grow and grow depending on your client's needs. So if you're dealing with clients who own multiple companies and have significant wealth, you may want to bring in corporate advisors, tax advisors, estate planning advisors to ensure if the company is going to continue and the spouses are going to continue to profit from it, that the legacy considerations are taken into consideration. Tax planning. What if the one spouse repartners? We don't want potentially that person making claims to the business. So lots of advantages when it comes to impasse and bringing in these neutrals to help you negotiate, or if you're in court, to resolve impasse. Carrie or Jonathan, you want to jump on those comments?
I really
for me,
like the story that you and Carrie tell about clients who believe that the other party is hiding money. And then you bring Carrie in to show, nope, there's no hidden money, or yeah, there's a big pile of money under the living room carpet that you haven't been paying attention to.
Yeah, that does happen every now and then. See, for
Or
me, it's
the envelope or the shoebox of cash, right? There's always those.
no, it's the money tree.
Yeah.
It's the money tree in the backyard. Mine died, but that's okay.
All right. So, Carrie, what do we need to know about bringing in the lawyers with respect to impasse?
You have to bring your lawyers into the process. I think it's about the lawyers bring in a really nice dose of reality for a lot of clients. I bring in a lot of reality in the sense that the money is the money. There's really not a lot of wiggle room when it comes to so much of it. But sometimes I need them to understand what is the reality of what they're saying. So if somebody's saying, no, I deserve half of that inheritance, and they're just kind of being a petulant child about the entire thing, then I need to be able to say to legal counsel, listen, we need to have a meeting and have a really good combined view of what an inheritance is and where we go from here on it. So for me, bringing in the lawyers to say, this is the law, this is what it means, this is what would happen in court. That for a lot of clients is a big dose of reality that they need to hear to get past where they're at.
Yeah, 100%. Or they realize how much it's going to cost if a lawyer has to get involved. Jonathan, 30 seconds or less, boomerang cases.
Yeah, so boomerang cases, I call them zombie cases. Those are the cases that you feel like you've gotten everything sorted out, it's all on paper, and you don't have to see those clients again. And then some new conflict comes up or a conflict over interpreting the agreement comes up, and the case is back in your lap. So my suggestion on how to deal with those is, and we talked about this a bit earlier, Russ, is to make your agreements as robust as possible. Make sure that if there's a lot of conflict, that you're very specific about all the financial details, all the parenting details in your agreement, so that there isn't any wiggle room for interpretation. And if ultimately they still can't resolve the issues, send them off to parenting coordination and hope that that will solve the problem for them.
All right. Well,
Great
on that
comment.
note, our hostess shows up just magically. Thank you, Shannon. Jonathan, Carrie, wow, what a presentation. I can't believe how quickly this went by.
This went really fast, really fast. Well
Alrighty.
It's a
done.
lot of fun, and you know, it's nice to see in the background that people are donating to Denise House and raising money for them. So thanks,
Yeah.
Russ and Shannon, for setting all this up and raising money for such a great cause.